This video covers something that most people in real estate investing never talk about openly, but it matters. And if you're going to work with us, you need to understand it clearly. I get asked about this subject often, so much so that we decided doing a presentation on this matter may be the most important thing we do when it comes to working with others on real estate transactions. We're talking about bird dogs, unlicensed real estate activity, and why the structure we use protects you in ways that a finder's fee agreement simply cannot. If you have the training module, this is the bird dog licensing risk module. Follow along if you have it. First, what is a bird dog? A bird dog is someone who finds real estate deals and passes them to an investor in exchange for a fee. They drive neighborhoods, find distressed properties, identify motivated sellers, connect buyers and sellers, and collect a finder's fee when a deal closes. It sounds simple, and for years, a lot of people in the industry have operated that way under one key assumption. As long as they don't negotiate, they are not doing anything that requires a license. That assumption is probably wrong, and in Arizona, it might make you a felon. Let me read you the exact statute. Arizona Revised Statute Section 32-2101 defines what activities require a real estate license. A real estate broker is defined as a person who, for another and for compensation, performs certain activities. The activity that catches most bird dogs off guard is subsection I, and I want you to hear this clearly. Subsection I says a broker is someone who, and I quote, assists or directs in procuring prospects that are calculated to result in the sale, exchange, leasing, or rental of real estate. That's essentially what a bird dog does. Finding a motivated seller and bringing them to an investor for compensation is assisting in procuring a prospect calculated to result in a sale. It does not say negotiates. It says procures prospects. And Arizona's definition of compensation includes the promise of consideration, whether contingent or not. A finder's fee that's only paid if the deal closes is still compensation under Arizona law. That argument doesn't work. Here's the myth I want to address directly because this one I hear a lot. Most bird dogs believe that as long as they don't negotiate price or terms, they're outside the scope of the licensing requirement. They're focused on subsection J, the negotiation subsection. But subsection I doesn't require negotiations. Procuring a prospect is a separate, independent activity that triggers the licensing requirement on its own. Finding the seller and bringing them to the investor is procuring a prospect. No negotiations required. Now let me tell you what the consequences actually are, because this is where most people in the industry don't know the reality. In Arizona, under ARS Section 32-2165, acting as a real estate broker without a license is a Class 6 felony. A felony, not a fine, not a cease and desist letter, a felony. A Class 6 felony in Arizona carries a presumptive term of 1 year in state prison. It can be mitigated to 4 months or aggravated to 2 years for the first offense. Repeat offenders face up to almost 6 years. The fine is up to $150,000 per count, and it creates a permanent felony record with loss of voting rights and firearm rights. And if you're a gun guy like me, that's serious. Now, a Class 6 felony is the least severe class of felony in Arizona. It's sometimes called a wobbler because prosecutors can choose to charge it as a misdemeanor, and judges can reduce the sentence. But that's not guaranteed, and least severe felony is still a felony. In California, where we also operate, it's a public offense under Business and Professional Code Section 10139. That means up to $20,000 fine, up to 6 months in county jail, or both. Corporations face up to a $60,000 fine, and California district attorneys are expressly required by statute to prosecute violations in their counties. There's also something important about California that most people don't know. BPC Section 10138 makes it a misdemeanor to pay an unlicensed person for performing acts that require a license. So in California, the investor who pays the bird dog may also be committing a criminal offense. The exposure runs both ways. And one more thing on California. Assembly Bill 1850, introduced in February of 2026. would explicitly require a real estate license to wholesale in California. It hasn't passed yet as of mid-2026, but it signals exactly where California regulators are headed. It's something you want to keep an eye on. Now, here's something I want to make abundantly clear. That payer liability provision in California, the one that makes it a misdemeanor to pay an unlicensed person for licensed broker activity, Arizona has the exact same thing. ARS Section 322155C states that it is unlawful for any person to pay or deliver to anyone compensation for performing broker acts who is not licensed at the time the compensation is earned. Same rule, both states. And for licensed investors and brokers, goes even further. ARS Section 322153 lists the grounds for license suspension or revocation in Arizona. Two of them apply directly here. Subsection A6 says you can lose your license for employing any unlicensed salesperson or unlicensed associate broker. Subsection A10 says you can lose your license for paying or receiving any compensation in violation of this chapter. So in Arizona, a licensed broker who pays a bird dog a finder's fee risks losing their real estate license. That is not hypothetical. That is what the statute says. I want to be direct about something before we go any further. Tobin LLC does not pay finder's fees, referral fees, or any other similar compensation to unlicensed persons for real estate activity. And I want to explain exactly why, because it is directly related to everything we just covered. I get asked by bird dogs all the time, why do you not pay finder's fees? If you don't, who's going to want to work with you? Let me be clear. It's not that we don't want to, it's because we can't. Let me explain. The members of Tobin LLC are active licensed real estate agents. We are also active licensed mortgage loan officers. Our partners include other current licensees. Those licenses are not abstract credentials. They are the foundation of our ability to operate this business, close deals, and serve our clients. If we paid a finder's fee to an unlicensed person in Arizona, we'd be violating ARS Section 322155C, the payer provision we just discussed. And under Section 322153, that violation is grounds for the Arizona Department of Real Estate to initiate license suspension or revocation proceedings against our members. In California, it is a criminal misdemeanor under BPC Section 10138. We will not risk our real estate licenses or our mortgage licenses for us, for our members, or for our partners for a finder's fee. This is the clearest explanation of why the joint venture structure exists. It is not just better for the associate, it is the only arrangement that protects Tobin LLC, our licensed members, and our partners at the same time. The associate is not being paid for finding a property. They are sharing in the proceeds of a joint venture deal in which they are a participating party. That is a structurally and legally different arrangement, and it is the arrangement that allows everyone involved to operate without the payor liability problem entirely. Here is a brief summary on the key differences in California and Arizona that we discussed. However, I strongly recommend you look up the statutes governing real estate in your jurisdiction or consult legal counsel. Now, the criminal exposure is risk number one, but there's a second risk that financially devastates bird dogs just as often, and it's less talked about. Here's the scenario. A bird dog finds a deal. They bring it to an investor. The investor contacts the seller directly, cuts the bird dog out, and closes without paying the finder's fee. The bird dog tries to sue. The court finds that the bird dog was engaged in activities that require a real estate license. Because the activity was unlicensed, the finder's fee agreement is unenforceable as a matter of public policy. The bird dog gets nothing. The investor faces no consequence for the circumvention, and by filing the lawsuit, the bird dog may have just disclosed their own unlicensed activity to a court, which could trigger regulatory attention on top of everything else. The bird dog did the work, they found the deal, they got cut out, and they have no legal recourse. I've heard conversations where wholesalers and end buyers make it clear that they have no intention on compensating a bird dog because they know they don't have to, and more importantly, there's nothing the bird dog can do about it. Now let me explain why this doesn't apply to you, The difference between a bird dog and an acquisitions associate working with Tobin LLC is not cosmetic, it is fundamental. A bird dog is a finder. A finder connects parties to a transaction and expects compensation for the connection. That is broker activity under Arizona and California law. I would also argue that is the case in many other jurisdictions. An acquisition associate working with Tobin LLC is a joint venture participant. You are a party to the deal, with a written memorandum of understanding, a deal confirmation letter on every specific acquisition, defined rights, and a share of joint venture proceeds. You are not finding a deal and handing it off for a fee. You are participating in an acquisition as a joint venture partner with documentation at every stage. That is a fundamentally different legal relationship, and it is what protects you and Tobin LLC. Let me leave you with 6 rules that keep this structure clean. Rule 1. Always have a signed MOU before doing any work. Without it, your activity looks like a finder's arrangement. Rule 2. Never accept a flat finder's fee tied to a closing. Your compensation is always a share of joint venture proceeds from a signed deal confirmation letter. Rule 3. Never position yourself as connecting a buyer and a seller. You are a joint venture participant, not a middleman. Rule 4. Let the deal confirmation letter govern every deal. Get it signed before doing anything deal specific. Rule 5. Don't operate as a bird dog for other investors on the side. Mixing models undermines the structure. If you intend to work with outside investors, we have other structures that can accommodate your business model. Rule 6. Don't quote or negotiate terms. You gather the information, our team handles offers and negotiations together. The bottom line is this. In Arizona, unlicensed real estate broker activity is a felony. In California, it's a criminal misdemeanor. In both states, finder fee agreements tied to unlicensed activity are unenforceable in court. The joint venture structure we use exists to protect you from all of that, legally and financially, but it only works if you operate within it correctly. This is not legal advice. It is our understanding of the law as applied to our industry. If you ask specific questions about your situation, particularly if you're operating in states other than Arizona and California, talk to a licensed attorney in that jurisdiction. The full written module is in your training materials. I'd recommend reading it. The statute language is in there verbatim. The penalty tables are in there as well, and the comparison between Arizona and California is laid out clearly. I'll see you in the next video.